welcome everyone. Without further ado, let me introduce everyone to today's moderator, Mr. Jeff Leong, Senior Partner of Jeff Leong, Poon and Wong. Jeff Leong.
Okay, thank you, Tyler. Good afternoon, everyone. I bring you warm greetings from Kuala Lumpur, Malaysia. I would like to start off with an apology for those of you who tried to join us on the 4th of June. Unfortunately, we were not aware that our Zoom platform on the June 4th had a maximum capacity of 100 participants. So that's the reason why we have this second round today, so that all of you could join in. Let me introduce a bit more about the organizers, the joint organizers. I'm the senior partner of Jeff Leong, Poon and Wong. For many years, we have been organizing legal English writing seminars for our own and workshops for our own lawyers, to train our lawyers. But because I was the fortunate invitee to Mr. Jerry Zhang's legal English classes in Beijing a few years ago, I attended twice. I thought that maybe because of the pandemic and none of us can travel to other countries, we would do a joint event with the Linli Law Office. That's why we have this joint webinar today. Of course, Mr. Jerry Chang is a famous arbitrator in Beijing, and he has this special class of Chinese lawyers and in-house counsels that is part of his English class, English legal classes workshops in China. Let me also say a few more words about the special welcome to the members of Sabah Law Society. Thank you for joining us. We are privileged to see so many of you being interested in this program. Apart from lawyers from Sabah, we have lawyers from China, the rest of Malaysia, from Kazakhstan, and various other countries in Southeast Asia. Let me introduce you the first speaker for today. Basically, our first speaker for today will speak about the ABCs of legal writing. ABC meaning accuracy, brevity, and clarity. Jack Tan Wai Kit is a lawyer with our law firm. I was working with him and I was encouraging him also to pick up some public speaking skills. We work together on our legal opinions, our transactions for our clients. And I took care also to make sure that he know all the intricacies of good legal English writing. And as a result of which, I said that maybe this is a good time for him to show what he has learned by sharing his experience with our own lawyers in the law firm. And I then widened this workshop to the rest of you through this open public webinar together with Linli Law Office. Jack is a graduate of the Multimedia University, and he's an advocate and solicitor of the High Court of Malaya, and he's now working with our Corporate and Financial Services department in our law firm. Our second speaker is Mr. Jerry Zhang Yulin. He has many years of experience in China, foreign-related civil and commercial laws. He recently co-edited a book on foreign-related laws and practice in China. He's also an arbitrator, accepting appointments as sole arbitrator, co-arbitrator, or presiding arbitrator with CTEC or Hong Kong International Arbitration Center. He received his Bachelor of Arts and Law degree from Peking University and his PhD in law from the University of British Columbia in Canada. So now I will hand over the time to Jack to start off his first lecture. Thank you.
Thank you, Jeff. Okay. So actually, before the start of the event, I just want to talk about some brief ideas of why I undertake this study. It's like what Jeff said, because I have always have a question to myself, like when I study in law school, why some of my schoolmates, why they can write in such a beautiful way, why they can articulate a point and deliver over in a very effective way, And then when I come to work, same questions arise. Why the senior lawyers can present and article and can write in a way that is like very clear and brief and at the same time very persuasive. That's why upon the encouragement of Jeff Leong, so I undertake some research and studies about how to ensure to write in an effective way, hence to that topic, ABC of legal writing. So as you can see, today's the outline is basically divided into three parts. The first part, we need to know why knowing this ABC of legal writing is important. And then secondly, we're going to discuss about the crux of today's presentation, which is how to be accurate, brief, and clear in legal writing. And lastly, we're going to explore do some case studies based on specific scenario and in terms of how to apply this ABC of legal writings in real life, in practice. So the first part of today's topic is about why knowing these ABCs of legal writing is important. As we all know, like data scientists deal with data, accountants deal with numbers, while lawyers deal with words. We deal with words as our living. So as this gentleman, Lord Denning, aptly put, he is a very famous, prominent judges and lawyer in the English common law system. He once said, words are the lawyer's tools of trades. It means like we use words as our to earn a living. We should master the art of how to words and how to write. As another prominent professor, Justice Kimball, has once said, we lawyer, we write and speak for a living. The lawyer who cannot write clearly and plainly and concisely fail to do their job effectively. They are like a carpenter who cannot finish a nail straight. It means that this is one of the very important skills a lawyer should possess in terms of for us to practice effectively. So, as we know, before we start to discuss further, we need to know what is the purpose of a legal writing. The overarching purpose of the legal writing is to make it easier for the reader to obtain from the legal documents information that will assist them with their professional making decision. The ability to write in such a way, like I said before, is the most important skill a lawyer can possess, and the skill that should be developed in the law course to help. In the law course, it should be one of the important skills that a law course should teach the students and master it during the School of Law. So, into that discussion, so the important thing is we need to know how to be accurate, brief, and clear in legal writing. The ABC in this context is accuracy, brevity, and clarity. In terms of accuracy, it's actually break down into two parts: accuracy in terms of facts, as well as accuracy in terms of the law. In terms of accuracy of facts, it means get the facts straight. In terms of the law-wise, it means cite the right law. Not only that, you have to interpret and apply the law correctly. So, how to ensure the accuracies in terms of facts? So, what we can do is we should take proper notes and gather sufficient information while we communicate with our clients. So, and also in today's, when we collect the information, there is an issue. Sometimes as a lawyer, we deal with a lot of information. As now, today we say there's a term called information overload. There's a lot of information that we have to see and to check, to review through. So it's always best to categorize, organize, and prioritize the information that we gather, so that we can know which one is the most important to tackle, to deal with. After that, we should also examine the information and the document at hand very carefully to check through, to see whether there's any missing parts, whether the information is up to date, etc. So it links to the next point, which is to double check, and we need to do a fact check to make sure it is accurate. So how can we do that? So one of the ways is like we can conduct some searches with public authorities to see whether the information that your client provide is consistent with what is reflected in the public registry. If the information is not sufficient, what you can do is you can ask for the confirmation from a client to verify the accuracy of the information or the information that is missing. So sometime on case-to-case basis, you should also conduct some further investigation, depends on the purpose or the use you are doing or the method you are handling. So on the next part, in terms of the accuracy, in terms of the application of law, it means that you need to know the law well. Basically, it can be broken down into a two-part process. First, you need to first understand the legal concept well enough so that it becomes internalized and become explainable, rather than simply memorize and reciting it. This is not easy, definitely. But the next part is you also need to have a stronger sense of big picture. It means you need to be able to link one legal concept to another one. So as explained in the second part of this page is that a legal concept is adequate conceptualized when a lawyer is able to comfortably explain it in an understandable way and freely discuss its relationship to other legal concepts. What it means when, for instance, when you see an issue of breach of contract, you should first link to the concept of whether there is any limitation to bar you from making a claim against the defendants, the defaulters. Also, you should also be able to link, for instance, like whether there's any remedies from law or from equity. Like for instance, can you claim specific performance? And you claim damages? What kind of damages? This is just an example of how to link the different legal concepts together and to have a strong sense of bigger picture. But this process is definitely very burdensome for all students, maybe young lawyers. But over time, as more legal concepts become conceptualized, it will get easier and easier. So there are some general guidance on to help you to improve the accuracy in terms of writing. First is to avoid generalization. Generalizations tend to means that when a person, give an example, what is generalization? If like a person eat a mango, if the mango is sour, then he feel like it's sour. Then the second time he eat a mango is sour. Then give a general comment and say, all mango is sour. This is overgeneralization, and this statement can simply be disproved by showing him a mango that is sweet. So generalization tends to be deviate from the accuracies in terms of the writing. So we should try to avoid generalization, overgeneralization of facts or statement. Secondly, we should use all inclusive terms very carefully. Words such as anyone, everyone, doubtless, all these have to be used very carefully to see whether it can actually represent or give a fair and balanced view of the facts in questions. And thirdly, you need to make sure that the spelling is correct and there's no typo error. For instance, a property titles under the grant number 123, and you type it to be 1235, it will be definitely, it will mean whole different properties. So you need to make sure there's no typo, there's no spelling error. And if you can think of, if you spell your client's names wrongly, you can see how bad it looks, right? So, and number 4 is try to avoid exaggerations. Use this kind of exaggeration used only in humorous writing. So in legal writing, in professional writing, we should not and should try to avoid using it. And on the 5th point is like, we should not inflate things beyond their importance. Look at things for what they are. And number 6, we should also, in terms of to ensure accuracy, we should distinguish facts from opinion. When we give our legal opinion in our legal report, or when we write a legal writings, we need to ensure that we base our writing on facts, but not opinion. And lastly, to ensure accuracy, we should check all the facts and law and make sure that the sources is accurate and reliable. So on the second point, brevity, it means literally try to be economical with words. It means that when we try to write, if you a legal concept, it takes usually, for instance, 5 or 6 sentences to be explained, but you can write it with just 1 sentence, that would be great. It's a skill that is hard to master, but if you're able to master it, you are close to able to master the skill to be brief. And secondly, it means you have to rewrite the wordy phrases and also reduce redundant phrases to ensure that you can keep it to the spirit of brevity. And legal writing that is brief is a step closer to an effective legal writing. So we have, based on the research, we're able to conclude 8 writing tips, although it's not exclusive, to point to a direction of precision, to be brief and concision. So the tips number 1, embrace brevity. What it means that is you should try to extra words and long words and unnecessary phrases may boost your word count, but that will not improve your writing. A writer is more effective when they make their points effectively without resorting to unnecessary words, redundant words, and redundant phrases. So it means that you should aim to communicate your point with the fewest words possible. If your writing is flat, tuned, or so-called boring, you can always beef it up later. So how to beef up is that you can try to use some vivid words or some more interesting words to make sure that your arguments sounds more interesting and solid and improve the readability of it. So, but at the end of the day, is try to deliver your point with lesser words as possible. So the tips number 2 is that use the words that you can fully understand. Writers sometimes may try to find big words that may sound sophisticated, but that may not be the precise synonyms for the simple words they are trying to replacing. Smart readers will spot this kind of false synonyms. A single word can turn the meaning of an entire sentence upside down if used incorrectly. Hence, while there is nothing wrong to have to use advanced vocabulary, always prioritize clarity and precision. If you have a deep pockets of vocabulary, it's always good. But bear in mind, just try to emphasize, try to prioritize clarity and precision. If a simple word can deliver the message across the board, use the simple words. So on the next point, we try to suggest when we write to ensure brevity in terms of writing, we should use technical terms sparingly and also carefully. We need to know our audience. If we are writing for a legal journal or to the court, it may be appropriate to use some technical jargons. But if we are writing to the general audience, to our clients, it would be prudent to use technical terms sparingly or try not to use it. Too many of them, particularly unexplained, will negatively impact the readabilities of your words and cause audience to lose interest. So this is examples on alternative to the legalese. So for instance, at the earliest practical dates, it can simply be replaced by the word soon or as soon as possible. For instance, communication, it can be simply replaced by what type of communication you are having, like letter, a memo, a telephone calls. For instance, pursuant to can simply replaced by using the word under, which is clearer. With regard to can be replaced by about, forthwith can be replaced by immediately. So we should try to use a word that is less technical and simple, and is more effective if we write in this manner. So if you can find a common English equivalent, use it at least with the general public, at least to our clients. Save the English, those are Latins, French, other foreign languages, supra, res judicata, save that for the lawyers. So on the next point, we should try to write in the active voice. Why? In a sentence written in the active voice, the subject tends to perform an action. For instance, he caught the ball, is active. The ball was caught by him, convey the same information using a passive voice and is in a less appealing sentence structure. This is because passive voice tend to harder to understand and it usually takes more words. So when given a chance, just try to use active voice. However, there are some exceptions to this general rule. Yes, in some circumstances, you may choose to use passive voice. Use passive voice in persuasive writing when you want to de-emphasize the actors or even conceal the actor's identity. For instance, if your client commits a crime, you might want to use a passive voice to describe what happened. On the other hand, if your client is the victim, means that you are the prosecutor, you should use active voice and active verb to link the defendants to the crime. Give an example. In this case, Mr. Robert is the victim. And if you are acting as a prosecutor, you should use active voice. You should say the defendant / Mr. Robert. Mr. Robert 5 times with the knife. But if you are the defendants, you should try to use passive voice by saying Mr. Robert was stabbed. And with that, you can somehow conceal the actors from this sentence or de-emphasize the actors. On another occasion, you may also use passive voice when you do not know who the actor is or when the actor's identity is actually not that important in the message, or when you want to emphasize the action instead of the actor. Give an example. The governor was told that 3 prisoners escaped from the state prison. In this sentence, it's not important for us to know who told the governor. What we want to know is what happened. 3 prisoners escaped from the state prison. So with this passive voice, we have emphasis the most important piece of information we want to deliver, which is the prison escape, rather than telling who is informing the governor, which is what we do want to emphasize here. And on the point, second examples, an experimental cancer surgery was performed yesterday for the first time. And then what we try to do here is that what we try to emphasize is the new surgery, but not who is performing it. So this is the situation where by using a passive voice may be a good way in terms of the legal writing. So on another point, we should use quantifiers as well as intensifier very carefully. A quantifier is a word or phrase that limits the reach of a statement. For instance, you could call a person the best athlete in the world, or you could call them the best American athlete in the world. This sort of precision can be a hallmark of good writing, but overuse of qualifiers can break down the sentence with preposition as well as weak languages. So intensifiers sometimes can produce a very strong statements. For instance, the word extreme in a phrase, the weather was extremely unpleasant, create a very strong impression that the weather is very, very bad. But graduate intensifiers can leave you with a long sentence that is needlessly wordy sometimes. So if your first draft of the legal writing is heavily based on qualifiers and intensifiers, please be ready for revision by starting to take out those needless preposition phrases and external words. By doing that, you're able to observe and ensure the brevities in your writing. And on the next point, we should also try to use various sentence length. Short sentence, long sentence, both have a lot to recommend that. So the key is to provide your readers with a variety. If your first sentence is a compound sentence with multiple clauses, make your second sentence short and simple. So amateur writers tend to fear of short sentences and erroneously believing that they are inherently less sophisticated. So to compensate for this, they end up producing one wordy sentence after another and fill it with vague words. So, and also bear in mind, a lot of great writers such as Ernest Hemingway and Judy Blume, they make their names on short sentence. So just give short sentence a try. If you can write with a short sentence, just give it a shot. And on the second point, another point is that we should watch out and be careful when we use normalizations. So what is normalizations? Normalizations are multiple word phrases that would be better replaced with a single word. Give an example. Give an assessment of, in these phrases can just be replaced by the word assess. So by replacing this give an assessment of with assess, you instantly save a lot of work and give the reader the right words without forcing them to read extra phrases. So when we try to write, we should rule out and reduce the use of normalizations. And this is we come to the point about avoiding double negative. Double negative is a big no-no in legal writing. When we try to write, writer must be aware that double negative arise not only from the obvious words such as not, nor, or un, but it may also come from words of negative meaning such as deny, forbids, or forsake. Double negative are most often used to mask uncertainty, doubt, or sometimes cowardice. So let us abandon such use. Occasionally, in the hands of a skillful writer, a double negative can appropriately convey a shade of doubt or blur an otherwise unpleasant start statement. But generally, we should try to avoid using double negative in our legal writing. Give an example. On the side of original is examples of double negative. For instance, I do not want no visa. It can just replace with the word I want visa. And I do not have no money can simply and clearly write with I do not have any money. And lastly, should do not spend but $2 can simply replace by should spend only $2. So as illustrated here, double negative does not convey a clear message and it tend to lengthen your writing. So to ensure brevity, check out and stop practicing using double negative. On the last point on characters, allow me to quote from Albert Einstein. He once says, if you can't explain it simply, you don't understand it well enough. So in order for you to explain a thing in a simple and clear manner, you have to understand the concept well enough first. So to be clear means that why we need to be clear. Clear writing is very important in legal practice because without it, cases that would be won are lost. Providing clear and concise information also means that there are less chances for ambiguity, question, as well as confusion when you try to make yourself understood to judges, other lawyers, as well as your client. So give an example. A child acquired overseas. Acquired, does it mean that he is purchased or kidnapped or born? Use the accurate word to describe the situation. Is he acquired? Is he purchased or kidnapped? If he is kidnapped, use the word kidnapped instead of acquired. So it means that when we try to write, use the clearest word that can describe the situation. And then there are some guides on how to be clear. On the point number one, or when we try to be clear, what we can do is that we can first start to write out our thoughts in a piece of paper in a logical order, write out the structures of our arguments of what we try to deliver, and then try to make things simple and specific when we write our arguments out. And then use punctuations. In a long sentence, it's always good to have a commas, and sometimes use proper punctuation can improve the clarities of our sentence. And link back to the previous discussion, we should use direct words and use the correct word when we try to describe a situation. And also, we can use headers as a signpost to guide the readers as to which part of this argument is, and also use paragraph and sub-paragraph to have a good organization and improve the presentations of our arguments and our writing. So lastly, read what you write. Cross-check it with point number one, the structure that you have write out in a logical manner, compared to the end result, the outcome that you have write out, compared with the structure that you previously write out to check whether it fulfill what you have previously write out in the structure. You write if it does not fulfill what you have previously planned to write. The rule of thumb to ensure a clear legal writing is to use plain languages. So for litigators, plain language is essential not only because it promotes clarity for busy and impatient readers, but it also is the best way to connect to the reader's mind and shape their perception about a case. Inflated language, so-called legalists, never inspires. For transactional lawyers, plain language improves user abilities to navigate the documents with confidence and understand what their legal rights and duties are. Direct language with informative headers and subheaders will make the document trustworthy and reduce the risk of ambiguities. So, give an example. So, it is determined here that can be simply replaced with plain language, like say we hold that. So, notwithstanding the complexities of the above mentioned issue, it can be replaced with the word, although this is a complex issue. Reference is made to your letters, in which you request that you provide an opinion as to whether can simply replace with plain language. This is the answer to your letters asking whether. In other examples, not from happenstance can still be replaced by the word not by accident. And possible benefits vis-a-vis utilization for personnel can better replace with the word possible benefits of using our personnel. So when we try to apply the ABC of legal writings, bear in mind the contextual considerations. We need to know who are the ones that read our documents. Readers are the ones that are reading our document, and they are the ones that judge a document whether it's better written or not. So a document is well written if the writing advances the reader purpose in reading the documents. Hence, when writers write, we need to recognize and take cognizance of the contextual considerations, such as the nature of the intended audience, as well as the purpose of the document in questions in the applications of the ABC of legal writing. What does it mean? So, remember when we discussed about the ABC of legal writing, there are some guidelines to guide us in writing. So, knowing who is our audience and knowing what is the purpose of the document will help us to balance between those guidelines that are conflicting. For instance, the writers knowing contextual consideration is important. It's because when writer, sometimes we have to balance between the use of plain languages and the use of precise technical terms. So when we determine what language would be most effective and engaging to the intended audience. So for instance, if we are writing to the general public, so it's always better to write with plain language and try not to use technical terms. But if we are writing to the judges, judges may be able to appreciate some technical terms if there is no alternative, some common words to replace technical terms. And it might work even well to the judge if you use the technical terms sometimes. So in that case, you can use more technical terms if your audience is a judge. So the writer may also have to balance between the use of a variety of sentence structures. So make sure the writing is structured in a clear way and make sure that the writing is engaging. So all this require you to undertake some thinking as to what is the contextual consideration, what is the purpose of this document, and who is the audience is. A writer is most effective when he writes with a purpose. So contextual consideration is important to help us to write with a purpose and therefore write effectively. So after we have done with the discussion of the crux of today's presentation, which is the ABC of legal writing, we now try to explain to you how to apply this ABC of legal writing in some case studies. So we have picked up a certain scenario as our case study. First is writing to senior lawyers. The document in question is the legal memorandum or the legal research. And secondly, we're going to discuss about writing to clients. The documents is the opinions letters. And lastly, drafting of a prospectus and other disclosure documents. So for writing to senior lawyers, and we write, senior lawyers are generally busy. So if junior lawyers are assigned by them to the task of researching legal issues and prepare a memorandum, a junior lawyer must not only research the law thoroughly, but they have also need to write the analysis in a way that can allow senior lawyer to understand it easily and understand the conclusion and their reasoning easily from the legal memorandum. So how can we do that? Basically, there are 3 points to guide us to write a good and effective legal memorandum. The first point is the 2-minute rules. So ask yourself the following questions. If I receive this memorandum without having to read through all the cases, would I understand between 2 minutes of reading this memorandum, my key conclusion and my rationale for reaching this conclusion? If the answer to this question is no, then you might need to prepare to redraft. So this kind of 2-minute rule is very important. Sometimes we can see in some reports from the governmental reports or some NGO reports, which lengths around a few hundred pages. They will have a part called the executive summary. They will give a summary in around 1 or 2 pages about what this report, what this document is about. So if you're able to communicate a lot of information and summarize it in just a short and simple summary, then we were able to master the skills of this 2-minute rule. So the second point on how to make sure we write a good legal memorandum is that you should make sure we're able to define the legal issue and present it with a short answer. So to satisfy the 2-minute rule, we need to take effort to define the legal issue properly and present a short answer. So in terms of defining the issue, it's very critical to provide senior lawyers with the information they require. So we need to ask the senior lawyer what are the issues, to clarify with them what are the issues at hand. Because if you have misunderstood or mischaracterized the issue, your research or analysis, no matter how impressive, will be useless. So if you are not certain, you need to clarify with the senior lawyers of what they are wanting from what are the issues at hand. And then you need to ensure you're able to write short answers. It means you need to able to summarize and give the essence or so-called substance of your conclusion and the rationales under them. So it basically, short answers is a synthesis of analysis and able to provide the senior lawyers with the crucial information they need. And it should not be longer than 3 to 4 paragraphs. This is definitely very hard. Personally, I'm still practicing it. So it comes with practice. Just keep practicing it. Try to think how to explain a concept in a very simple way and with less word. Just keep practice. And on the point number 3, we need to make sure that the legal writing, the legal memorandum in this case, need to be clearly organized and present the analysis in a very brief and clear way. So we need to explain succinctly the facts of each of the case on your analysis, and also explain your findings in a case and how you apply it to the issue at hand. So sometimes it's always good to group and analyze those common cases together rather than analyze it one by one. So another way is, as discussed earlier, use headers to serve as a signpost to guide your readers, and always write clearly and simply. With this in mind, you can improve your legal memorandum that you submit to your senior lawyers. So on the next case study, writing to clients, in terms of the documents at hand is opinion letters. So before we pick up our pen, before we start, we need to ask and think who is the audience and what is the purpose of this letter. So who is the audience of this letter? You need to understand your audience legal sophistications and their levels of involvement in the case. So this information will guide you the level at which on how you need to address your analysis and the nature of the language you use. So if your client maybe is a legal professor, he is well aware of all the legal concepts, you can use some legal technical terms to deliver your message. But if your audience is a layperson, it's always good to use simple plain language to deliver your ideas across. So we need to know the purpose of the letters. So before start to write an opinion letter, ensure you understand from the senior lawyers, partners in charge, what is the letters intend to achieve? Like, is it to provide an update, give an advice, establish an action plan? So knowing that will help you to know how you're going to direct, to write, and to put together your analysis and discussion. So in the opinion letters, as a lot of as a lot of you may understand, we know is that it basically breaks down into 4 parts, which is introduction, background, and then the analysis, and also end with a conclusion. So in the introduction, the letter needs to introduce your work to the client slowly and in a bite-sized manner. So the introduction should not do more and not less than introduce the purpose of the letter and to provide an outline of what you are going to tell the client. And try not to be greedy, just introduce what is the purpose of the letter. That's the purpose of an introduction. And then after that, we'll come to the background. So in the background part, we need to provide some background story or information about the matter that you're handling into the letter. So with this, you actually continue to warm up your clients before the legal analysis, which is the crux of legal opinions. So the next part, in terms of the legal analysis, which is the heart and soul of the legal opinion writing, is that you need to, before you start to write, you need to prepare an outline to think of how and what is the best way to explain your reasoning and conclusion. So prepare the first draft that focus on achieving the logical coherence first, and then you can start to redraft it to make sure it fulfills the ABCs of the legal writing, the characteristic of the ABC of the legal writing, which is to make sure that it is accurate, brief, and clear. And then when you use the case, you need to use the case appropriately. And when referring to a case, make it clear to the client why you are talking about the case. In other words, explain clearly how the case tied to your analysis, linked to your analysis. So sometimes and I would say is always when we try to write, do not refer to too many cases. Referring to a good and the leading cases, so-called the precedent, is good enough to explain that can explain the principle is good enough. Try not to use too many cases. More is not equal to best in this case. So now we come to the parts regarding like drafting a prospectus, other disclosure documents, and other disclosure documents. So what is a prospectus? Prospectus is actually a public document that the issuer need to file with the regulators before they can issue securities to be subscribed by the public. So security commissions have issued guidelines regarding the prospectus, and since it's a public document, they have sections in the guideline discussing on the using the plain languages for the prospectus. So as you can see in the tables, so in the SC guideline, it said that the previous style company tried to do is they will say company, for instance, ABC per heart, and then bracket hereinafter refer to the company, have how many directors, how many of them is independent, how many of them is not independent. This company have how many assets and how many liabilities, what is the company business. So what SC try to say is that we should not use that kind of writing. Instead, we should just replace that kind of wording with we, like as if I'm the company speaking to the investor, like we have how many directors, how many of our directors is independent, how many of them is not independent, we have how many assets, we are engaging in what kind of business. Use that kind of word will be more engaging and more readable to the general public. And also, the guideline also say when we draft with clear and concise sentence, use common everyday words, avoid superfluous words, use active voice rather than passive voice, change now to words, use less legal jargon as well as financial jargon, use positive sentence and not multiple negative, as we discussed earlier, and use defined terms sparingly, as little as possible, and also use effective layout when you present the prospectus. So not only that, in terms of other disclosure documents such as announcement or circulars, the Bursa Malaysia's main market listing requirements have also give some general guidelines that what is considered what is the requirements of these public documents, public disclosure documents. It said that it have to be factual, clear, ambiguous, accurate, and inclusive and contain sufficient information. No, not misleading, not deceptive, and then give is balanced and fair. Give a balanced and fair view. Avoids over technical language. Use or language that is comprehensible to the layman. So what does it mean? So if we are going to advise client in drafting of the prospectus or other disclosure document, it would be always helpful if we could first able to master the ABC of legal writing. So now we come to our conclusion. So in today's, when we apply, so what can we do is that we need to apply and practice the ABC of legal writing as frequent as possible. It's not easy, easier said than done. Like it's require a lifetime of practice. So keep practicing it. So like a lot of people say is like practice make perfect. Just keep practice. Think about how to apply it in the practice, and just keep practice. And not only that, we also need to take into account the contextual considerations. So like the two questions we to ask, who is your audience and what is the purpose of the document in questions? So this is to help you to write with a purpose. So a writer is effective when he writes with a purpose. So asking this two questions always. And another thing to conclude is that when we write, it's always good to have a second pair of eyes to check our document, to review and double check. It's good to be for the document to be double checked or reviewed by our colleagues and better senior lawyers. So, but sometimes if you have to work on the matter alone, no issue. What you can do is that, so you try to complete your document first, put it aside to cool your mind and your eyes and do other things. And after that, you get back to check the document with a fresh pair of eyes. With that, hopefully you can able to spot any mistake that you do, or to think of how to improve the writing. So, and lastly, make sure that when you write, you deal with the issue at hand and answer the query posed. So this briefly summarizes what we have discussed in our presentation earlier. And this is the reference that I refer to when I undertake the research in giving this presentation. Thank you. I think I have done with my presentation today.
Thank you very much, Jack, for your excellent lecture and presentation. Our next speaker is Dr. Jerry Chang, Yulin, from Linli Law Office, our joint co-organizer of this legal English writing webinar. He will be speaking on cross-border drafting of commercial contracts and arbitration clauses. We will also be privileged to hear Dr. Jerry Chang, together with a guest speaker, Mr. Thomas Manson QC, who is based in Beijing. He will be a guest speaker together with Dr. Jerry Chang. Mr. Thomas Manson QC is currently teaching at the in Beijing, Peking University School of Foreign Languages, and he will later this year be teaching at Beijing Foreign Study University Law School. Over to you, Jerry.
Thank you, Jeff. I'm trying to get back to you. I pressed some button that works to minimize or
you're this one. They can't hear you too.
It's something that asked me to hide, but I pressed something.
I think yeah.
This one?
No, there's if you go up a little bit, just to the arrow. No, if you touch that blue arrow, no. Okay.
Jerry, you can look at the bottom of your screen. You can see something that looks like you can broadcast this thing rather than keeping it in this.
I button, and okay.
Is it working?
Okay, let's just start with the slides if possible. Can you see me?
Yes, we can see your slide. Yes, we can see your slide.
You can see me.
We can also see you, yes.
Okay. Can you see me?
Yes, we can see you.
That's great. Yeah, then we just start. I pressed the wrong button maybe. I'm Zhang Yulin, lawyer and arbitrator in Beijing and the founder of Beijing Linli Law Office. I'm also a member of the China Arbitration English Teaching and Testing Committee under China Academy of Arbitration Law, CAAL. So I'm very grateful to Jeff Leong for coordinating, and also very appreciating CAAL support for this work. we've been workshop in legal English for the past few years because we feel that this is an interesting area for international cross-border communication. And with the help of Mr. Q, with us through the long road of legal English workshop, we have sort of strenuously working forward on these different topic of work. And thank you, Jeff, of course. We did a workshop with CTAC 2 years ago on arbitrators with the Loasia group. These moments are very still in mind. Now, this is a time of change, as we all know, a time that in Chinese we say, 年不遇之大变局. It's a change time, unprecedented over years. And a lot of people are thinking, what are the changes? We see clearly the change pandemic and resulting changes from the pandemic. We see the changes of climate change, the new concept proposed, people working on that. And we see the changes of number 1, 2, geopolitics of the world. And we probably will see more of these sort of continue in the future to have a fair competition rather than sort of defeating each other, that kind of step. You cannot get rid of away from the world, right? It's a globe and we all live here as human beings. So the world, developed world and developing world, there's always been here with us. So we are facing privatization or diversity time. And we have to face change. The differences are there, from long history. Greek philosophers, Plato and Aristotle, have just concept that everybody has its due, right? It's more about each person has its due from the duty and responsibility to be a person, that point of view. But from the Chinese Oriental world, we have a few myths, concept of, everyone is born good. Everyone is born good and into a family, and family as a unit of the state, and the state, in the pictorial character of characters, the state has a sort of round square in between. It's the territory. So that's the state. The concept of state is there, and that in every Chinese mind. So we are very much sort of collectively oriented. We are, and part of the family, of course, first, and then the state. So we shoulder a concept of, in the state concept. And that's a part of the culture, and that culture probably differs from Western Greek philosopher-based concept. There are these differences. So we cannot deny the commonalities, which is that we are all human animals, right? We have to so we live together socially. So these things are very common. Like, we use chopsticks. Go to West world or Europe, you use knife and forks, right? But the function meeting, the function, they are the same. Sending food to your mouth, because as human beings, we need food. So if we look at the commonalities, then probably, will be easier with each other in terms of coexistence and relationship, because today's topic is really on contract writing. It's a civil, it's a commercial relationship. And I'm an arbitrator. I see a lot of contract disputes. I like to speak out in a more sort of neutral scenario about the need to contract in good shape so as to avoid disputes in the future. So with that, we will go to the slides on why we do legal English. It's my brother. It's a very good friend of mine. Over the past more than 10 years, we have been teaching and collaborating, and we actually co-edited the recent book signed from and then we finished the book recently on foreign related laws and practice. So he is a professor at the university, School of Foreign Languages, the cultural program, and now he will be shipped to the University Law School, and with courses common law and other legal English and legal courses to the current world. Now, I introduce myself, and first is why we do drafting, right? And contract drafting essential practice, and then legal English writing rules. We'll cover the rules and the case study, particularly the arbitration clauses. Arbitration is a very good means of resolving dispute. And with arbitration clauses drafted clearly in the system of dispute resolution in the future, so you will be more sort of active with future conflicts and dispute resolution. Legal drafting in English for international business. English legal drafting is important for lawyers. First of all, we all know that the lawyers for clients. Lawyers are engaged by clients. And in this book, it's a professional, it's edited from All China Law Association. It's interesting to know that lawyers in China are undertaking the roles for 4个性, 4 roles. One is to support the rule of law. Number 2 is to perform the social duties in terms of certain lines, and so the social aspect of lawyers' work, different lines of industry, right? Lawyers you all need that in mind, because law is really all around scheme that covers everything society is under the rule of law, under law, right? So lawyers deal with maybe shipbuilding contract, or it's a railway and a railway contract, or it's a telecom and it's telecom contract. If it is, you are engaged by service. But interestingly, that there is a public duty for lawyers to perform, because the integrity and rule of law, but also lawyers has a private aspect of the social relationship with client, because you are engaged by a specific client, engaged by a company or B company or a group or a social or society or association, whatever, but you are engaged under a specific engagement. So with that engagement itself, you are actually privately engaged, because you as a lawyer or a law firm and the other side of the line is agree. So there is a private aspect of the relationship with the client. And in Chinese, 私权，那这个是律师工作当中的一个挺有意思的方面，就是 you are actually private engaged. Autonomous law society is relatively autonomous. In China now, we have about 150,000 lawyers now all around the country. And professionalism, of course, we do legal memos to clients, we write prospect, etc. All of these written work needs legal and facts a lot of ability training. It's a very professional work. So these are the four ethical duties. Lawyers have to be loyalty to the client. Lawyers are equipped with both the facts and the law in a specific case. So we always deal with facts and law, and quality of legal service require us to be able to draft documents in English, right? Because the Chinese society is becoming more internationalized. So we have to deal with the international aspect of the legal services. Continuing education requires that. So legal drafting for international business, as you know that English is widely spoken, now also widely spoken, used in China. Many foreign experts, they choose to live and come to China, live here, and then they are sort of integrated well in the society, language that they use, right? English or learning Chinese ago. And a lot of people can speak English now in China, especially younger ones. There's programs that people interviewing street goers and asking, do you speak English? And many speak English. So English is widely spoken in big cities like Beijing, Shanghai, Guangzhou, all of these cities. You can easily meet people speaking English. And of course, Malaysia is basically English spoken country, I understand. So that's the interest that I think it's good that we can have this kind of English writing rather together with statutes and judgments in English are readily accessible. This is very interesting phenomenon because legal is relatively autonomous, right? Legal society, every country, and the law is guided by judgments, particularly in a common law system. And these judgments are searchable like can-li, C-A-N-L-I-I, Bay-li, B-I-L-I, Li, Australia, Hong Kong Li.
I think our speaker
Hear me?
Yes, we can hear you now, Jerry. Go ahead and speak.
Okay.
Okay, good.
Okay. So let's move on to the next slide. Drafting in English. It's a common fact that English is the most widely used language in the world. Although Chinese is by native speakers is the native spoken language in the world. In terms of usage, English is the most widely used. So the phenomena in the future, in the next generation or next decades, to see that if more Chinese become English speakers, or if more speakers become Chinese speakers, then the world basically will be more peaceful because communication, is relatively easier with the most language world. So that's a thing that it's interesting to watch out in the future. Now, legal English in English, as we know that documents in writing function to determine the rights and obligations of the parties in a specific situation. Now that's an example that, like in CTAC arbitration rules, the language may be agreed, and Chinese is default language. Now, if parties do not agree a foreign language, then Chinese is certainly the official language that is the default language. But it's English language in China, in CTAC, or in other arbitration institutions, the language choice, then basically you can use English to go through the whole procedure of arbitration and then an award in China. Of course, you can enforce that award by translation and then go to the Chinese court, because the court requires all documents in Chinese, and that's a fair and you have to just translate into Chinese. But in the arbitration world, at least English can by the parties, and once the legal drafting in English is done, then your rights and obligations will be determined in the legal documents. Now that's an example that in the recent court jointure to be set up by the investor with the local party, and then there's a lessee relationship between the venture and the lessor, and the parties agree in the contract that in the event that the lessee is not established, has not duly ratified this contract on or before a certain date, right, September 15, 2003, any out of control of the investor may terminate the contract by 14 days notice to the lessor, beginning or before that date, October 15th, 2003. So these dates basically determine your rights under this contract. Now, in that case, the investor unfortunately failed to give the notice of termination before the agreed date, but give a termination beyond this date, and was found to be in breach of the contract. Now, this is an example that the contract terms will set out your rights and obligations under the contract. Now, this is just a phenomenon. There will be a contract period, a term of the contract, right? So you can pay attention to the term, because these terms will basically determine how far your rights and obligation will go under the specific agreement. You want to extend the term, you need to have an extension agreement, extension clause, right? Now, legal issuers certainly do what we do, right, to give advice to client and communicating effectively to client in the language. We are in the world with a language. Everyone speaks a language, right? So we have to express our ideas in language. Ideas may be formed, but if you don't express in a language, then there's no communication. And expression of ideas through these documents in writing. And that's what lawyers do. And that's why we need to improve on legal drafting all the time in English or in other languages. Now, the second part is business international. What is foreign now? Now, I'm in Beijing. I look at China from internal perspective that we do what we do every day, right? Go to office and do work, whatever emails we deal with, whatever documents we need to clear, and whatever a procedure here we need to. And these are the normal day-to-day work that we do. But if you look at external perspective, look at China, what is the foreign relationship, foreign related elements? There's both internal view and an external view. If you look at the legal relationship, the first thing you look is the parties. Now, who are the parties? Whether the parties are from outside China. If the parties are from Korea, from Japan, then it is a foreign related matter, right? Because from countries, parties from China, both are from China, but the matter, the legal relationship changes in Canada. We have an example later on, that company lending to another Chinese company who failed to pay the loan back, and whose CEO or general manager immigrated to Canada, also failed to repay the loan as a guarantor. And then this creditor, Citibank, pursues against the CEO in Canada by issuing a injunction. And in this specific case, the defendant applies to invalidate the injunction. The award is really about whether the applicant the injunctions is entertained or not. But the element that we are talking about, the four-related element, that originally this case is between two Chinese companies, a lending, right? But because the general emigrated and then the relationship changes under the guarantee, so it becomes a foreign-related element. Now, if say parties are in China, right? A foreigner living and traveling, so he has the rental agreement, purchasing, banking, and travel agent, all of these contracts will be foreign related because this foreigner and a party, the party is a foreigner. Right? If it is a real estate developer from overseas, age time to help purchase local property, that's a foreign related matter. Now, this is a case, a real case that we handled in Beijing, a company, Shanghai company, but the project is in Philippines. So there's a Philippine project, power plant, and it is applied to Philippines. So the relationship involves foreign element. It's a subject matter that so in the sort of overview, you have the parties' relationship and subject matters. And under the latest Chinese law, there's also an element of place of residence in case of natural persons. For those natural persons who may share the time in one country to another country, and then the most time is spent is in country A, then the country A could be considered as a place of habitual residence. And then, in Chinese law, then this habitual residence will be an important element to determine whether it's foreign related or not. Now, foreign related matters in China, in the sense, why they matters, in the sense that in the future, when you set up your arbitrations or your choice of law clauses, in foreign related matters, you can choose foreign law, you can choose foreign arbitration. These are available under the law. But if it is purely domestic matter, then I'm sorry, you probably take on this choice. So that's why we talk about human foreign related element, so that you will have that stand in your contract drafting. Because when you can't do contract drafting, it's not just only the wording, right? It's important that we use correct form, grammar, and correct spelling, but the idea, the relationship is as Jack mentioned, the contexture of the relationship is important. So that's why we would like to cover this foreign relation. Now, contract draft essentials. I would like to invite my good friend Thomas Manson QC to elaborate this part on draft. And Tom, the floor is yours.
Thank you. Let me begin by just making a claim that I don't think any of us here are suggesting that there's a universal practice and that legal English is universal meaning. Certainly in my study and in my extensive university, I've come to the conclusion that legal English means likely different things in different cultural contexts. So it means different things in different practice contexts, whether you're in a litigation practice or a commercial solicitor's practice. In any event, I think we should recognize at the very outset that there is that cultural division, and so certainly appreciate the variability of legal English or plain English or however you want to describe it. That's the first thing. Another thing, just before I get specifically into the drafting essentials, I wanted to just acknowledge the contribution by Michael Wong in 1990, published in the Malaya Law Review, an excellent article which is particularly appropriate to the subject that Dr. Zhang and I are speaking about, namely plain English and drafting and criminal contract. Michael Wong, in that Malaya Law Review article 1990, spoke about many of the things we're talking about today. So it's interesting that you know, here it is, 30 years later, and we're still concerned about these things. So as a profession, we need to be aware of the challenges and the reason for legal English and plain English, and we need to be aware of the opportunity to draft more effectively and communicate more effectively, and to do so in a way that follows up on the long established identification of this as a problem area in the practice of law. Now, so that's the first acknowledgement to my colleagues in Malaysia. The other one is Dr. Radu's paper to the IBA in Tokyo 2014, which is referred to on the particular slide. It identifies different sorts of contracts, and while we are attempting to write for the drafter and the role of the drafter, it's also for context important to identify sometimes not drafting, or the elements of drafting are limited by the context. If it's a standardized contract, then you have a contract and you essentially fill in the information. You have a modified standard form, and with some limited variability. Model contracts create a greater opportunity for drafting, and of course, with the most flexibility and drafting role turned over to the professional, the ad hoc or bespoke contracts. And again, that's discussed in the Professor Raju's 14. I also, certainly in my practice as a litigator in Canada, I'm now retired previously, most of my work would have been based on contract precedents and bespoke contracts relating to the particular litigation where, for example, settlement agreements needed to be drafted, that kind of thing. So I think the point of this slide is to emphasize there's a range of types of contracts, and there's a range of role for the different legal professionals in carrying on work. I note on this slide the different types of standardized contracts. Sometimes they're required by law, sometimes they're and third parties, for example, multilateral development banks may require standard contracts. Dominant parties, such as energy utilities, may form model contracts. There's various kinds of model contracts. These include institutional development contracts, and many of you will be familiar with, anyone doing construction engineering law will be familiar with these and other institutional types of contracts such as those. And then legal publishers, of course, provide standard contracts as well. And they offer an opportunity. The model contracts here offer an opportunity for drafting based on a model. Now, it has to be recognized that there is some. I think this is a slide coming up here just a sec. I've talked about certainly not all model contracts are the same. And there's a range, and you need to get the model contract that's appropriate for your exercise, for your project, whether it's FIDIC or NEC in a construction tech or some other text. ITC provides model contracts as well. The criticism of the model contract, the concern about model contracts, is, as the second bullet on this slide says, model contract very of serious consideration and revision. So they tend to be a general framework and require an element of understanding to the circumstances. And that's where, for example, Jack was speaking about get your facts and importance of understanding fact context. And that is absolutely critical because you choose the wrong model contract and you've got a contract which doesn't suit the needs of the parties. And clearly understanding the needs and getting an appropriate model is objective. One of the concerns that professionals, contract drafting professionals have is that these models are not static, and that the current model may bear resemblance to an earlier draft, and you've got to make sure that you've got the latest draft, and you've got to understand the differences. And so the change is not always an improvement. It may be an improvement, but you've got to be aware of the evolution of the contracts. Sometimes the number of provisions increases, sometimes it decreases. As plain language lawyers, we might say, well, generally a decrease is better, but not always. And there's reasons, you've got to understand the reason why it takes place and then draft accordingly. The same thing in terminology, that similar terms do not always mean the same thing. They certainly don't mean the same thing necessarily in jurisdictions. So a term in legal English spoken here in China may well mean something quite different from a term in legal English in North America, in Canada, where I'm from. We've covered this ones here. I want to just say something about the issue about sentence length and the number of words per sentence. One of the things that I've concentrated on my university work is the idea of using technology, and certainly that is for applications, and certainly I think it's got a role in contract drafting, where in order to ensure the accuracy of the work, it's often a good idea to run your work through a ability check, a grammar checker, spelling checker, and so on, and that can be done through Word or Grammarly. So especially for second language, where English is a second language or a third language, then this sort of use of technology can be quite helpful for assisting with, although we're dealing with technical terms, it can still be useful as a starting point first through before the more detailed word by word review by the lawyer is done. The other thing that ought to be mentioned is that in the was speaking of the matter of structure and the importance of structure, headings, and other elements, well recognized in theory, at least in the literature on language drafting, and is certainly noted by Michael Wong in that 1990 article that I referred to previously, and the importance of using headings and using structure, and thinking of structure as an element in draft, whether it's English for a letter to a client, or plain English in an agreement, or plain English in a litigation. In all of those, there's a need for appropriate structure that provides clarity to the communication. So I think, and this, what I wanted to do here was just to illustrate basically the drill down. I think, Jared, did you want to introduce this first?
You know, these are some of the essentials that are very important in practice. We use later on, there's some summary slides as well, because like in arbitration, in CTAC and other arbitration commissions here, the first thing when you file an application for arbitration, the commission will check with you whether your name of the parties are correct, the address is correct, the contact person is correct. And then the commission will, according to its rules, serve these documents, the applicant, to the respondent out of the rules that require accurate information of these. And if the party from the beginning, make a correct provision on name parties, that actually, it's easier for future, or avoid any mistakes in the future. Recitals and preface, these are very important elements for contracts as setting out the background. Definitions, depending on the contract, because there are, as Tom mentioned, standard contract, FIDIC, and other contract, very lengthy contract for a big project. Then you have a lengthy definition, and then the drafting techniques will probably require you to put these definitions, at the beginning of the contract or at the end. But definitions are necessary to determine the parties' understanding of, the certain roles, certain terms are used. For example, China. China is a country, right? It has a definition in international law. So if you say that according to the law of China, and the definition on the international territories, including Hong Kong, Taiwan, Macau, under international law. So, as a private party, you can define whether the law refers to specifically mainland China, or the politically understood concept of People's Republic of China, the mainland part, or including Hong Kong or in Taiwan. So you can, as a private party, depending on your needs, because let's say if you are a private seller, right, you want to sell the market and you want the market to be a big one, then you can certainly define that these things will be particularly this territory. You have the freedom to define that, and that at party point of view, you can consider that. And in the future, whether the law will be using law or Hong Kong or the law of Macau or Taiwan, for example, these will be determined at the time according to perhaps the conflict of law rules in China, perhaps the judicial interpretations, and international. So, but as party autonomy, when you do the contract, you can define, this is part of your freedom, define things that you need to have them defined. Relative sort of in a free approach, and I hope that these will be understood in this context, like term. I meant that if you want the term to be clear, a 10-year term, then the question is whether how end the term, right? If the early termination is required, or whether there's a lack of pre-expiration notice and what will happen, whether extension is allowed. All of these may be considered at the point, and then to have your dispute resolution, on the list, also considered in the context. So confidentiality, important provision. The term confidentiality is very interesting because it's about the commercial contract, right? You have a commercial deal with your partner in China, and then you want to be low key, so you say that this is not information, because this is part of our deal, right? Involves my sort of side of the trade secret and your trade secrets. We have confidentiality clause. Now, because of that clause, and then you also have arbitration clause in this agreement. So arbitration is covered by the whole concept of confidentiality of your commercial agreement. And that is why arbitration is confidential. You know, if you ask why arbitration confidential, you know, people sometimes worry because it has an element of publicity, right? Public interest. Now, if everything is taken private, then all dispute resolution bodies can complete their mission of public sort of integrity and activity of sort of applying the law correctly, etc. You know, how can they have their confidence? So the question would be, why is confidential? The reason is really because the private agreement is confidential, because it involves both these secrets. They do things, the way they make the deal happen, right? So these things are all related. You understand the confidentiality in arbitration. If you understand that it really goes to the party autonomy, so then you understand, oh, that's why, because these are their you know, women, the neighbors, our neighbors, and we are not supposed to sort of interfere with their contract. So then you understand the value of the confidentiality there. And essentials in terms of specifics of arbitration clause, we'll come to that later when we go to the slide there. We covered this part. You know, there are various needs and different sort of legal tools for you to consider when you deal with a specific request from client, because if you are dealing with a guarantor, you know, like the example that I have, the general manager guarantee the loan. So there's a guarantor's duty. Then you want the protection of the guarantor's obligation. And from credit's point of view, you may consider the right to injunction there, right? You know, because the injunction relief basically like a Mariva injunction, that in case the guarantor fails to pay within a year after the breach, right? Then they to have injunctive relief. So you can build in these are legal tools, right, in the systems. You can build these to in the future. You can rely on these tools already in your agreement. Of course, if you have these tools in the agreement, legally speaking, you are still able to seek law, but then you have to sort of research later on when the dispute arises, and then if really say another country, then you have to sort of research early on that kind of relief. But if you put that clause in the agreement, then in the future you can rely on your own agreement for the injunction relief. And certainly there are various terms of interest, you know, like the language term, language version, you know, whether English is which version will prevail in case of differences. Or you can say that both versions will be valid and authentic. And then the arbitrator, the judge, will have to look at both versions. And in case there's a students, and what happened, you know, you probably will rely on some of the guide under that legal system, you know, whether the intention of the parties reflected in which, you know, after first, and all of the background facts will come up to have a play on determining of a specific issue. Yes, yeah, you can add a few.
I wanted to step add a comment. When we look at a list of terms, such as the here, and then we drill down into, for example, dispute resolution or confidentiality, that there's huge scope for extensive drafting provisions if those are warranted by the transaction, the client's instructions. And you'll remember from Jack's comments about the importance of context. And although we as lawyers generally strive for certainty and clarity, and one of the things we speak about is the importance of clarity, sometimes vagueness is higher or set. And I want to give and so this is an exception to the general principle that we've been discussing today. So for example, your responsibility is to your client, but on the other hand, the drafting that you do must be acceptable to the other side. And there are reasons that a vague provision might be appropriate. One, it might be based on which to make an argument at a later stage that there was an obligation on a party that wasn't perhaps perfect expressed. And so that's one sort of the reservation of a argument contemplated in the future. The second one would be that the vagueness might be a compromise. It may be that the other side is well represented, your client is well represented, and it may be that the crystal clear solution to victory for one side seen as a zero-sum situation by the other. So the solution is a vague compromise. It's not original. This is something that Michael Wong wrote in his 1990 famous article on plain and social contracts. But I think it's a very good point that there are times where a vague provision or less complete certainty is an acceptable outcome, provided everyone understands the risk. That is that arbitration tribunal at some point may say that the imprecise or vague provision doesn't work out the way it might, or doesn't give the basis of an argument that the other side, a duty that the other side has.
Thank you, Tom, for the additional point. Sometimes in practice, you have to be very practical in order to accomplish the job that you are faced with. Now we come to the third part of today's talk from this end. Contract drafting essentials. We heard most of the part in the previous slides. Applicable law specifically, we looked at applicable laws, approach to drafting, look at the nature of the contract and the nexus to contract, or whether the contract is a technical contract or it's all of these may be different. Now, choices of applicable law for BRI projects. When we approach the choice of law, there is an element practically to consider a sophisticated system with the in-depth rules and precedents available for different projects. And you may consider from BI and the BRI projects, you may consider common law as part of the choice of law, like Hong Kong, because Hong Kong is based on common law, and it is relatively neutral for parties. If party is investor from China and the other party is, say, from Ethiopia, and then if parties differ on the choice of law, you can consider a neutral place for the choice of law. Hong Kong is relatively neutral. It's part of China in terms of constitutional governance, but it has its own jurisdiction of law, and it's based on the common law system that is internationally well recognized in common law. Hong Kong law could be part of the consideration. The point that I wanted to convey is really when you consider arbitration clause and choice of law clause, these clauses, neutrality is always element. Now, sale of goods contracts cross-border within the Asian region, for example, you can use ISG as a governing body of law to deal with the contract right now with buyer and seller, because CISG has clear provisions as to when a buyer needs to take its obligation to pay, when a seller have to deliver, and if at certain point of time the buyer does not pay, and the consequences of that failure would clear under the CISG. So you can consider CISG as a independent law in your relations. Now, some of the changes in this new world, like technology changes, and some ecosystem may be developed under a different applicable and connected system. In those situations, you may consider dispute resolution clauses and governing law clauses in your specific situation as to Chinese law should apply. And if so, then why? You can protect these laws. Now, for example, Chinese law has an element of fairness. That's personal view, but I think it is because the simplicity of the system and the scope of or the discretionary scope of that arbitrators and judges or the adjudicating persons. And the fairness thing is something is connected to the judge and arbitrators, and it's not deprived by the private parties, and basically under the current law. So, unlike some of the rules in Untitled, for example, model law or that here, this is Untitled model law, the arbitral tribunal shall decide on ex bono or amiable compositur only if the parties have expressly authorized them to do so. That is provision, I believe, is the resulting provisions out of negotiations of the common law system and civil law system, and ultimately, lawyers agreed that we have this provision, that if the parties express the authority, then the arbitrators can do ex equo et bono, basically fair, it's fairness. It's the reason that this provision is there, I believe. But in Chinese law, has been always that the arbitrators and judges, they have the authority to consider the dispute in a way, based on fact law. The fairness approach, they have inner authority to deal with that. And so in our arbitration work, that we have to deal with these fairness talks, with this way or that way, and how to balance the interests, competing interests, and finally give your decision. So in the at least in what we do in that sense, because if we have this in law, then we say, okay, we'll just do according to what the parties agreed. And if you agree, then that's the consequence you have. That's the job. If you do that, then you have to have, weigh those situations fairly. Remedies needed and mediations, when you consider ADR clause, consider mediation. Now, remedies needed under English Arbitration Act, and also some other the arbitrator's powers are expressly provided, similar to, and then they can give remedies expressly listed under the Arbitration Act. And these are actually a very we consider in the future in terms of our arbitration law, which we can certainly take these into account, how arbitrators communicates about the responsibility that arbitrators have to deliver. And if the law are clear remedies arbitrators can give, then arbitrators would be, relatively more guided, felt at the loss, what to do. Too much, too broader scope of authority that give a hard time for delivering the work. This is BC law that is covered under to English Arbitration Act. Now there is a preference of contract drafting as the one of like we prefer short form contract. We, I mean, in China, at least in the Oriental, probably if we have the same feel like Japan, Malaysia, maybe also, we in Oriental world, we more likely like a shorter form contract, right? Setting out the key rules between us and with the general principles that are forward under the contract. We cannot enumerate all instances of possibility in the, but in the many of the model contract, FIDIC and others, there are a lot of experience in past project development, project performance, and those experience, failure or success are built into years of legal, professional, continuing education, and upgrading documents. All of this give us a good, very thick model contract. And that's a good thing, of course, because it's occasional experiences and good rules. But in the developing world, China is a developing world. In a developing world, we are more likely to be accustomed to a short form contract. So from the developing world, you may expect that these thick contract must be signed, but you should also have some room for understanding that the developing world really looks at a more simple form of contract. The intention to work together, the form of the contract could be reduced to a relatively acceptable level. Like I was looking at some of the or some of the arbitration awards, and I'm trying to limit my time of research and I look at sort of pages, 10 pages, and be interested to look further for legal principle because it's a time-based thing, right? If you have 20,000 pages, wonderful job. It's a detailed picture, much more thick than ordinary writing. It really requires years work. It it builds something at a lot of cost and research. It may be appreciated for a particular project. So preferences, various other preferences we may, but as reality, I said certain preferences from certain region could be by communication better, could be understood better that at the time when you do the deal, you can have a reasonable level of tolerance, inclusiveness, and that helps work collaboration, work together. Certainly would like to cover the legal English writing rules that we have been often used for students and workshops here. Brian Garner's, Brian is Bryan, Brian Garner's Leading in Plain English. It has a group of 50 rules and it's very good, well illustrated with exercises. And it's a good text for junior trainees and lawyers and paralegals and writers to review. Some of the keep a good order in logic order and chronological order. These things are put. And this list, interesting that you can count your sentence length by looking at it. You can count the words and see how long the sentence is. If it is less than 20 words, it is actually preferred. So when we do writing, we can also learn from that and try to use a word instead of a few words. Like what Jack mentioned, normalization, right? You would normalize or assess, right? Or give an assessment of, all of these are things that you can improve in your editing period. Once you've done something, then you can do editing. Voice over passive voice. Active voice and passive voice can have different functions, right? Passive voice may be used in many contexts when you emphasize the subject rather than the active action verb. And there are other rules of choice for you to use sentences, and then rules for analytical and persuasive writing, briefs, memos, court documents that need analytical and persuasive force. Then you write that format. You consider the issues, the rules, the application, and the conclusion. The paragraph, the beginning and the middle and the end. So in order to improve your writing. Now, each paragraph, you could have a topic sentence. When I was in the English department at Peking University in 1983, and then through the studies from our teachers, I heard that the teachers told us that you should have a topic sentence, for each paragraph. I was not fully appreciated on the meaning, the real meaning of that, until I get to learn and started to write. And then I understand that it's really a sentence, a leading sentence for you to lead the idea first in the paragraph so that the readers could be saving time, So use a sentence, that's a technique. And in terms of writing your counter arguments, and this is also very important because in Chinese we have the concept of 兼听则明. 兼则明就是if you hear both sides, then you are intelligent. So that means that when you're only one side and you make a decision that based on one side story, that is not an intelligent decision, but it's partial decision. So the way that you deal with it, you have to hear the counter argument, the other side. And that actually, I think it's part of the procedural justice from our customary 普通话, it also reflects the procedural due process that we as human beings need to have in order to be, making intelligent decisions. So consider your counter arguments deal with the argument. Now these rules from 31 to 40, rules that advice from Brian Garner on drafting contracts. Organizing provisions in importance. If you look at some examples here, for example, this is IC's 2021. I look at Article 30 about expedited procedure. Then you look at the list 1 to 3. You can consider number 1 is more generally applicable. Number 2 is more specific. And number 3 is specific. So these are the drafting techniques, the more important ones put at the beginning. less important but more specific follows. Now, there are some different views about the from Brian Garner. Delete every shell. We often debate on that, and with that, we still should keep the shell, because in our world of legal drafting, from where I was trained at the time, we often use shell, and in context, we use shell, and Tom has always been suggesting that we should follow the in every shell.
Well, yeah, I want to qualify that and to say that this is a perfect example of the choice to be deliberately vague. And so, for instance, what I was speaking of before, these and many other plain English scholars say delete every shell, as they say, because judicial decisions have on a number of occasions concluded that shall doesn't mean must, and shall means may or otherwise. And so the concept that you might use shall allows for argument potentially that shall means may. This may seem counterintuitive, but Brian Gardner and other scholars point to the number of court decisions where this is the outcome. So I think it simply illustrates the point.
Yes, thank you, Tom. Yeah, you are right. In many cases, shall may mean may, and you know, you remember the New York Convention also, you know, have these terms that you can consider real there. So there are some different perspectives, like the Hong Kong arbitration clause recommended model clause. You see shall. That's the way that I'm seeing a lot of. We see that the dispute shall be referred to and finally resolved in arbitration by International Arbitration Center, and the law of the arbitration clause shall be Hong Kong, and the seat of arbitration shall be so. Be, and the proceeding shall be. So it's all about shall. You know, these are recommended from one institutions, and certainly this is an existence. I think it's a phenomenon that this market does not necessarily have to be perfectly in line with what Brian Garner. Brian Garner is also in the world because the editor of the Black Law Dictionary, so certainly his authority is very well recognized. But the view may be just a view of that book. You know, the reality that in real life we have to look at now as a not counter argument in support of what Tom using must instead of shall. I must say that CISG is the United Nations ancestral model law for the International Convention for the Contract of International Goods, CISG Convention of 1980. There you will find that the must is instead of shall. So the seller must and the buyer must. And you know, these words, there is a good example to support Brian Garner's view and Tom's here. It's an argument in terms of using shall. So whatever we use, the purpose is to try to clear and making the meaning clear. If it is a must, then probably it's better to use must. But if it's something that shall can stand, then you can, you know, easily, safely using shall. Let's move on. And then there are about 10 rules for document design and improvement. So the purpose is really by working diligently, systematically, you will have a well-produced document for your client work. Go here, clear, concise statement of facts, structured paragraphs. These are the goals of the good legal English writing, plain English writing, right? Other texts you can also see in the market, like Lawyer's Guide to Writing Well from University of California. So you can use others' books. Now, finally, top time limit, we have to be short in terms of arbitration clause. It's important to have an arbitration clause for your contract because, as we say, to the benefit of the parties and protects your trade secrets, right? So try to use an arbitration clause. If the court, then the media will be behind these facts and then just go public on everything what you've been doing. Unless you're required legally to disclose, it's a better policy for companies in the market to keep low-key and confidentiality most important principle. And some of the clauses drafting, be careful, is one of the previous V's arbitration moot that certain rights has rights that prevails over the other party. That may be a gold mine for litigation. So be careful drafting. Consider predictability, New York Convention, model law, consider judicial activism, whether you need that, whether the system has judicial independence and rule of law strength. And courts only review procedural part, but do not have expansive review. And will be the parties will look at. If the courts expansively review arbitration and then revisit what the arbitrator have decided, then arbitration may not be very appealing to the parties in the market, because the global platform for arbitration, that part of the work, if decided by the arbitrators, the court is hands off. The court will basically respect what the arbitrator have done in terms of substance. If there are procedural defects, then the court maintain and preserving due process, right? The duty of due process from the administrative justice. Have a look at the defects of procedure and then have the authority to either invalidate or decide or refuse to enforce the award under the New York Convention. So the concept for arbitration is pro-arbitration, support arbitration. The reason is that the parties agreed and you choose arbitration. ADR, the alternative, meaning that it's a dispute resolution means arbitration in place of the court, to replace the court. So once arbitration is chosen, then the court, just stay in the role not to interfere, but to support and refer the parties to disputes. This is the case in Hong Kong. It's a Chinese contract involving subcontract, and the arbitration clause is like one arbitrator for arbitration, and the arbitrator issuing award will be final and binding. But at the end of this clause, there is a limitation that before completion of the subcontract work, without the general contractor's permission, no one can refer to the various arbitration. So the dispute then sent on whether the court should stay the court, the court should support the arbitration, and the finding that in that case the court still should stand in favor of arbitration, even though there's a different view as to whether the subcontract work has been completed or not. Case, but it shows that the court is there to support arbitration by giving the opportunity to arbitration, referring the parties to arbitration. Now, this is what the New York Convention says, that the court shall refer our parties to arbitration unless the arbitration award is arbitration agreement is not capable of being performed. Basically, the arbitration prevails. Parties need. We have some room for the future to improve in the sense that can refer the parties to arbitration where there's no element of invalidity. But what the law stands now is that the courts still have a role in case of dispute on the validity of arbitration. It has a role, and then notify the arbitration whether to proceed or not. So hopefully that in the future, basically using the terms that the New York Convention used, and that actually simplifies the whole process and also gives a confidence to other parts of the world that China, complies everything in this part in relation to enforcement of arbitration agreement. Good news that this is in this Linli case to use ICC Court of Arbitration rules for final arbitration in accordance with ICC rules, place of arbitration in Shanghai, China. Previously, before this case in 2013, I think, so it's 2013, there's a spelling mistake. 2013, before 2013, the ICC arbitration rules were considered invalid, but after this case, ICC considered it. So this is a good example to show that Chinese Supreme People's Court stands very much in support of the arbitration world in China by giving positive and in supportive replies to the thing. So possible arbitration clauses in the future in the region, this is just an illustration of how you select, because recently Queen Mary and Wine case, they have served some good ranked arbitration institutions, ICC, SIC, HKI, CTAC, and LCIA. Now, of course, this, because I'm sort of standing in Beijing and I look at internal view, that's my internal view. So I list here these institutions, like the parties agree, 103 arbitrators, referred to arbitration by 103 arbitrators, appointed in accordance with arbitration rules of United Commission for International Trade Law. It's very well recognized and very well welcomed in China. So we can constitutional rules as the main rule. And if it is China related arbitration, of course, China in China undisputed. So you can use CTAC as, or in the region, HKIs, because HKIs really stands in a jurisdiction common law in China, because China now, look at China now is not only a civil law country, it's a country combining with civil law from the mainland and common law. So, your approach, external approach from China may be different from 10 years ago or 3 years ago, but the internal approach should also change, that China has a combined system of civil law. If we understand that and change our mindset to fit into the reality, then our legal lawyers communicate each other may be easier, because we should learn more about common law rules, and then we can understand the law, and then we can help clients build their contracts better, right? Communication better, more active. So you can choose these arbitration rules at your choice, because each project is different. Part negotiation position may be different, expectation may be different. You know, these arbitration clauses may be at the end of the process of a successful deal making. So early on, you can get advice choosing that fit your project. Now, this some of these clauses could also be negotiating reality. You know, you can sort of hold this point in bracket until finally the client document be probably by trade-off. We can agree that law is China law, place of arbitration is overseas, or other way around, or you know, a more neutral place to consider these factors. And which I think is important, and it's also something that you should value because English is so widely used, and the English world is very much sort of jurisprudential, is far, far advanced. In that sense, I would suggest that feel free to use English for the Chinese users, because you know, it's not only a language issue, but it's a jurisprudential issue. Can get easier to the jurisprudence in the English world if you agree on the English language. Now, that not say that Chinese jurisprudence is relatively less. It's a developing system, and a lot of new concept is adopted and for in China, and it's a good phenomenon that a lot of legal system building is taking place in China. And we, the more we use Chinese language, also the better we can improve the system. So you can consider your subject to use the language, but the language is not killing. Is not killing thing, you know, in the deal, right? You can initiate by, the law is more important, or the place of arbitration is more important. The language I can give, I take. So it's a negotiation process. Now, we are close to the final section. Just a short summary, why legal drafting is important. I have a friend. Yeah, Tom, just let him in. Yeah, sorry. Anyway, essential commercial contracts. Applicable law, ADR clause, drafting notes. Finally, we say rule-based combined with principles. Rule-based, sometimes you set conditions and you basically are setting out your own rules. If the rules are not included, the principles could be included to back up. So when you draft your contract provisions, in case that there are some vagueness, then you can better, for drafting purposes, include some of like good faith principles, like diligence principles. You know, the principles, it will help you resolve the interpretation of the contract. Drafting definitions are important, and legal interpretations is important not only in private international law, international public law as well. So our book on the recent foreign law practice has a chapter on international norms and domestic norms. And we look at the norms of legal interpretation in international public law, and we look at the international legal interpretation under contract law in so basically they are very much similar, or a lot of methodology, saying, looking at the intention of the parties, looking at the words, the ordinary words that are used by the parties in the documents. So, that when you draft, use the ordinary words that are familiar and to the piece. Because from a lawyer's drafting point of view, the client is the person receiving the documents for the clients. And logic in reasoning, that's always bear in mind to the logics in the legal world. Okay.
Jerry, we have very little time left. You should look to end your speech because there are 2 questions, after which I think you still want to launch a book. No? So we have
yes,
very
I just wanted to summarize. Thank you, Jeff.
Yeah.
Thank you very much. I want to summarize that language years, right? So we should pay more attention to language when we use drafting techniques. And also, the world is changing, as we say, that the contract becomes more and more important. Because of that, we believe that the contract is becoming more important in this side of the world. So we can advise clients more focus on making and contract performance in the future. So that ends my PPT. Understand that our approach is a blended approach with common law and civil law, and it's not really giving us here. We like to share experience and perspectives, and hope that we are heard so far. Thank you very much for all your attention. We're just
okay, thank you, Jerry. Thank you for sharing your perspective on cross-border drafting of contracts and arbitration clauses. And thank you also to Mr. Thomas Manson QC for being our guest speaker today. Jerry, there are 2 questions basically from the audience. They basically want to understand Chinese contract law because, as you know, Malaysia is a common law country. The law of contract here is very simple. You must have offer, you must have acceptance, you must have intention to create legal relations, consideration, as well as certainty of contract. So they are asking, what are the basic elements of a valid contract in China, as well as whether there's a General Contracts Act in China?
I think this is changing as the law grows. The law, like foreign investment law, that requires equal treatment to the parties in the market, domestic parties, SOEs, private-owned companies, and foreign investment companies. So the law changing, and that helps the private market to pay more attention to what the contract says and agreed between the parties. And the principles of party autonomy is very well recognized in jurisprudence in China. So in our daily work of dispute resolution, dealing with arbitration claim and counterclaims, we look to what the parties agreed first. And then if the parties have agreed and which is clear, then we'll just follow what the law provides the remedies as to consequences of breach. So the more attention is really paid to what the parties have agreed in the contract. And then in the performance, who must perform their contract. It is also very much emphasized in practice in ADR, in distribution, not only court and but also Chinese arbitration world, particularly the foreign-related arbitration world. So that creates a sort of changing phenomena. The concept that contract just a form, and it really does not matter too much as to relationship may also change, because the dispute resolution produces awards that are based on contract terms, contract clauses, and the courts support that, and that has impact into the private market.
I understand. So, you know, I think the person who asked the question basically is comparing to a situation under common law in England, where law of contract is found in cases where there are certain basic elements of what constitute a contract. And then in Malaysia, like in India, we borrowed the Indian Contracts Act, where it specifies the definition of contract. Certain things or certain factors or elements must be met before there is a valid contract. So they are just curious whether in China, you have a similar contract law that tells the parties, the people out there, what is a contract, or what is a valid contract. But looks like from your answer, I don't think there is such a contracts law, right? You probably have your own China commercial code, but I don't think your commercial code will go into what is a contract. Is that right, Gary?
I must say, Jack, you're not correct in that sense. We have a contract law. You know, contract law changes in the 80s. There is an economic contract law in the 80s, drastically, and then there is a foreign economic contract law in the 80s. And it changes to, in 1990, late 90s, we have a unified contract law that combines economic contract, foreign related contract, and technology contract. So there is a contract law. Now we have a civil code. You know, it's a very gigantic project for the Chinese legal system that were completed last year to have a civil code this year. And the civil code combines the contract law, the property law, security law, and many other laws in one code, so that it's easier for the users to look at and check and the laws. So it's a very a masterpiece work of many minds putting into this work. And contract laws is the fundamental part of the civil code, and it deals with all important aspect of legislation, you know, whether it's commercial contracts or it's technology contract, IP contract, licensing agreement, just service-based contract, legal engagement, or, you know, it's an entrustment agreement. The provisions are clearly set out there, and one of the key provisions is that contract must be performed. So that means that, you know, you and I, and the Asian world needs to understand China better in the way to understand what the code says. Right? Perhaps in the future we can do some more of these webinars, workshops, so to help the legal, at least the lawyers in the society, law society, to understand the Chinese contract law, civil code better. And then when you deal with your work from China or in China or dealing with China, then you can sort of be more equipped to deal with the contract, sort of in uncertain, unknown, unprepared situation, right?
Okay, thank you, Jerry. There's one more question. It's a question that is asking about the independence of the Chinese court. So in this situation, I think that they're asking whether generally for people outside China, there is an impression that the Chinese court is not independent. So to see what your views are, I think from what I know, the Chinese court has been used by foreign parties in China as well. They have been coming up with decisions that I think are fair, especially in the disputes over intellectual property. There are instances where the foreign parties win in those sort of cases. But I'm looking from outside based on what I hear. But the question is there an impression that Chinese court is not independent? Over to you, Jerry and Thomas, whether you can give an insight from inside China on this question of judicial independence of the Chinese court.
Thank you, Jeff. I would rather reserve it to another time to talk because of the limit. But briefly, I had done some research about, because we have independent trial 独立审判 independent trial. The system is terminology in 4 characters, and I would advise and actually I strongly suggest that we may put this impartial into that system, 独立公正审判, because in arbitration law we have the 独立公正 independent and partial word there. So these wordings are important for in the Chinese texture, you know, and the trial, independent trial, you know, my research in the PhD is really on the independent trial process and look at the legal logics that are embedded in that trial. And I argued thought that because of the legal logic, you know, we need to have a better understanding of the system from judgment, because once you find facts of infringement, right, and then the remedies are legally by the knowledge that we learned from law school, the remedies are clear, and the judgment follows these legal logic. So while there might be different perceptions from previous specific individual cases, and then media interpretation in a narrow situation, that might take place. But overall, because the system is here and the logic is here, and that supports the growth of the economy. You know, why China grows so fast? Hey, wait a minute, because there's a system that supports millions, every year attains 100 millions of cases. Maybe I remember it's like close to 100 cases from the courts, and all kind of cases, civil, criminal, administrative, all cases together. It's millions of cases complete every year. There are reported cases of bad examples, corruption, etc. But the most majority of cases settled. That's it, and that really gives the stability and the peace of the society. You know, that's why people enjoy and grow life here, right?
Yeah, thank you. Very good. So Jerry, over to you and Thomas to talk about your book before we end today's webinar. Thank you very much.
Yeah, the book, I will mention the book, and I just, maybe one of my friends is buying the book from media, from online, and he's saying that buy and send law schools, and then he likes my calligraphy, so he likes me to write a few words. He will use that as a bookmark. But, you know, I want to say thank you all for your attention, for my friendship with many years with friends in the circle. And without your help, we cannot accomplish that book. And without your continuing support, you know, we were just doing limited daily work. And I hope that, you know, we will continue to work forward on helping others to make life better, right? Make it better. Thank you very much.
Okay, thank you. We have come to the end of today's session. If you are interested in Jerry's book, feel free to reach out to us. We will send you information on the book and how you can buy it. Basically, Jerry has written a very important book in China, in English, on how to ascertain foreign law and foreign-related practices. It is a book of many different chapters written by different parties relating to foreign-related aspects of practicing law in China. Okay, I think I don't have any more to say except to thank the speaker, Jack, Jerry, as well as Thomas Manson QC for giving an excellent presentation of the topic today to help us understand how to write better in legal English and also how to draft better cross-border contracts in English and better arbitration clauses. Thank you very much. And I think if there's nothing else, I think in the chat box, I think there's a request for you to fill up some feedback form. We will consider opening up other training in legal English workshops, as well as other training in future, and we will contact all of you again. Thank you very much and good evening. Have a good weekend.
Thank you. Thank you.
Thank you.
Thank you very much.
All right, thanks, Jeff. We have just launched a poll at the bottom of the screen. It will be very helpful if we can get your opinions on it. So we will really appreciate it if you would spend literally 2 minutes to fill it in and give us feedback on this seminar. We will keep this room going for a while, but once you're filling the poll, you're more than welcome to leave. Thank you so much.